Gentlemen, thank you so much for joining us on the podcast today. How are you, Rod, and how are you, Neil?
I'm very good.
I'm well, thank you, Peter, and thanks for the invitation.
Well, it's great to have you back, Rod. A lot of people got a lot of benefit from our last conversation, and you suggested we bring in Neil to actually explain and to educate where we are at this particular point in history here in Australia and why it is such a historic point in time and everything that is coming out of this at the moment. So I'm going to hand it over to you two, but I would ask you, when you're explaining this, that myself, I know very little about politics, and possibly our listeners are up to date, but possibly they're not as well. So generally, and no disrespect here, but I always ask people when they're explaining things to do it in a way that my mum, who's nearly 80, and my children that are in their teenage years, they can understand what it is that you're educating us and informing us about. So over to you fellas about what is so important that we need to know right now.
Okay, well, look, I'll do the introductions here, and thank you for the opportunity of coming on to your show. I find it very inspirational and a great platform, and the good work that you're doing, Peter. But look, I will. It is complex, but we will do. I'll certainly. Well, Neil and I have spoken about it. We'll put it across in layman terms so that it's understood. Look, it is a great leap in time in the nation's history, and the best way to refer what has happened just in this week is a Commonwealth mateship with the tribe, a tribal mateship, and it's just a fantastic step forward for all Australians. And a memorandum of understanding was executed with the original sovereign tribal federation with the elders right around this nation, with the tribes. And it's about respecting one another's rights. They are bound to their law, which is spelled L-O-R-E, and equally we're bound to our law, L-A-W. But in order to move forward in this great nation and work on where we are in time and how we're seeing the states, in effect, usurping the powers of the Commonwealth, so overriding our Commonwealth Constitution, which is the protection of the rights of all Australians, it must be better understood that we both move forward together, and that we always must be mindful that the law that actually governs this great Australia is a UK Act, and the United Kingdom have oversight and are responsible for their act. And we must hold this current government and administration of government to account, because we say, or the law states, that they, in effect, with the Australia Act, until that's dealt with in the UK, in effect, are usurping the powers of the Commonwealth and allowing the state premiers to rise above a stream rising above its source. And as much as people not Clive Palmer, and we understand, there are issues with the decision makers and advisors within the government, and we say the Australian government is not recognised. And when we say we, the law of the Commonwealth law states it, and this must be addressed. And in order to do that, we had to advance matters unprecedented into the United Kingdom, which is what we've done. CO 588 is a judicial review holding the Deputy Governor of Western Australia to account for jurisdiction and how this has all been played out. And the original Sovereign Tribal Federation, OSTF, have recognised that there are issues with this current administration and how unelected officials are basically having power to, in effect, keep people in house arrest, which we've seen play out, especially with Steely Dan in Victoria and Palaszczuk up in Queensland. And, at the end of the day, it's not about what they say is theirs, it's ours. It's our rights, our country, and we are the beneficiary to that. So Neil Piccinin is joining me today, and I thought it was a prime opportunity as the prime mover for the matter in London. He went over to the UK, the original Sovereign Tribal Federation noted or listed down as interveners, and Rural Australia Intervention Directive, which is the Australian farmers have also filed an intervention in the matter of CO 58 of 2020, which is another giant leap forward. But can I say I'm so proud, you know, as all Australians, we must put our differences aside, respect one another's rights, otherwise we're just not going to ever seek remedy. And Great Australian Party is about seeking remedy, is about putting the proper laws in place, bringing back laws that may have been revoked, we say can come back, and that's what we're doing. So look, I just think it's a great time in the nation's history to have the original sovereigns of this country come out and actually publicly announce that they've entered into a memorandum of understanding with the Great Australian Party. It's unprecedented, it's gone down in history, and we can only just say thank you very much. And we're both sailing to London. They've got OSTF on their sails, we've got GAP on our sails. Both yachts are sailing to London and the spinnakers are full, and because we need to get back honest government and reclaim back our great nation before we lose it. And that's the principle and the ethos of the Great Australian Party. So I'll hand it over to Neil, Peter, and thank you.
Thanks, mate. Neil.
The carriage that I've come onto in delivering this message after returning from London on the actions of the Chief Justice of the Supreme Court gives us license to audit this whole debacle that's gone on for decades in Australia. My background may be referred to as a dedicated informal academic, having studied law initially in high school in Melbourne and later in TAFE at Perth, augmented with a history of researching the law. During that time, I engaged with inquiry of aspects to validate authority with government, departments and agencies, and along the way collect a library of records to understand the legal position and the issues and the subjects upon which they were focused. It's about proving the authority claimed by government that seems at odds with the law that I've studied and that's currently being used as their authority, right? What my records point to strongly suggests in a convincing way is a realization that our house is very much not in order. And more disturbingly, the government generally knows of it and has known of it for decades. The reaction of public officials when confronted with information is mixed. Some are surprised, some are in denial, and others do acknowledge the information but do nothing to make right what is wrong. The official government records that I've accumulated speak for themselves and are not readily available in the public realm that may be referenced by the public or law students. And what these documents do is paint an entirely different picture and destroys the legal narrative currently promoted as an authority. These documents have been made over different time periods which show intent and purpose to lie to the Australian people by different generations of governments, where the latter concealed the crimes of the prior governments or advanced the crime to greater levels as we see now. It is incomprehensible and without reason that myself or my colleagues can identify. And we have made inquiry to understand why is this being done. Right. A colleague of mine, Mr. Dixon, has a web page portal at constitutionwatch.com.au that publishes some of these documents. And he's made generous of his time and money to provide this free to the Australian people. And we hope that the officials and the scholars refer to these and make themselves knowledgeable as to where and how some of these things put in place are not in order. My position is, when a government no longer administers the nation's affairs according to law, I may ask, why? And why is it that you do not follow the law? Where do you get your authority to claim to be the government of the people in Australia if you're conducting yourself outside the law? And that's what the records show. And it's bewildering to understand the disparity between the official narrative claiming constitutional authority and what these records show that they know they're not operating within it. The whole thing is a game of charades, and it concealed what they were trying to do as if they were doing it quite normally. Australia, as a term, for all intents and purposes of legal records, is a landmass, and that we share with the tribal people before us. It is a geographical, not a political body. The Commonwealth of Australia is the legal and political body. So Senator Culleton at the last election made a video, a speech beside the river in Perth on the importance of our Commonwealth and the meaning for which was well shared at the time. It is important to note that the term Commonwealth of Australia legally represents us, the authority of the Australian people. Remove the word Commonwealth, and now you're left with something else that is not the people. So it is the authority by which to run government, and it exists in that order of superiority, with the Queen representing the Crown, coexisting with the people over and above governments. The legal standard we hold government to account is Crown law, and reflected in the opening paragraph of our foundation law that established our Commonwealth by the words, an indissoluble federal Commonwealth under the Crown. Those words are really the door entry into the courts in United Kingdom, because while we are under the Crown, we have the whole opening and protection of that Crown. And the courts can't deny us. And until they change and take away the words under the Crown, it must be taken that we are, and therefore we have protection. But what they have done in Australia was to remove the word Commonwealth and the Crown, because the Crown is synonymous with the Commonwealth. And if you take away one, you take away the other. This is why they did several things in unison to remove that and create legally virtually another trust. But that trust isn't based on law. And a trust, why I say a trust? Because the Crown's a trust. And we operate with people acting under fiduciary responsibilities. And they say this, but they're not doing it. And out of that is where our rights are as a people. We can claim a right of protection by claiming the Commonwealth or by claiming the Crown. And what they've done is taken away both. And why are we interested in having both, or the Commonwealth? Because there's a standard of law that protects us on how we solve our problems and hold our governments to account, so we don't have a shift in authority giving us a different set of goals and standards. Some countries have quite bad human rights records. They're not well protected by the law structure that they have. And the English law system has been fought for over 1,000 years to get to where it is now. And we have various protections like the Magna Carta, the Bill of Rights, the right of petition. And those things are set in law. And by removing the Crown, you've lost those.
So in saying that, what I'm translating from that is that currently Australia is operating, or the government is operating outside of the law?
Yes, there's a clue about it when you read carefully the preamble of an act made in 1973. The act was to create a title for the Queen for her to adopt so that she'd be advised by Australian ministers instead of UK. Our constitution requires that ultimately the UK government has oversight to make sure that we're on the correct path. That's in section 58 of the Constitution. It's also within the clause that requires the Queen to be bound to rule and serve as she had promised in her coronation. And she promised to serve the people of Australia. So rule and serve come together. That's what they did in and she ruled as that for 20 years up until 1973. And then they did a switch by removing her title so that the UK government could no longer have oversight. But that's not available in law to remove it. In fact, the law of England ultimately has a Treason Felony Act, which says to remove a rightful title of the Queen is sedition. It's treason. The rightful title is where it's written into law, and it's written into Australia's Constitution Act. So they're saying this is our authority, but they're not abiding by that because that title that's required at clause 2 is not being used. They've used another one that the Whitlam government pretended to have authority to create, and they're using that, and they're using a different seal, and they removed the term Commonwealth out of various acts at 1973. It was a wholesale change to create another jurisdiction that is not of the Crown and not created by the Australian people. It doesn't represent the Australian people's authority. It represents government authority.
So how did the Queen, did she know about this? How did that happen?
And this brings in also another misconception about what the Queen is and what the Queen does. In English law, the Queen gives up her powers to the government and the Parliament. She does not exercise them. It's like, I'm giving you this product and I've licensed you to use it, and you have the exclusive right to that product. The Queen bears no responsibility. It's the government. If the Queen interferes, they complain to say, you don't have the right to exercise these powers. You gave it up, because they went from a hereditary monarch in England before 1700 to a constitutional monarch, a construct which the Parliament took over, and therefore the English people now control the Queen. Instead of the Queen exercising those powers, the people are doing it through representation in Parliament. And that's the misconception that everybody blames the Queen for not having done this or that, but she's just there for us to exercise her powers, both the Parliament and the people, because the people have a right through exercising their right under right of petition. And that's how we deal with one another, through Crown law. And it's a form of republic, if you might say, where the people have the power and exercise it. It's capturing that power that was ultimately given up, where previously it was exercised by the king. And that was after the Glorious Revolution, and it's one of the best models of a republic that I can, understand or see.
So you gentlemen have instigated something, or are instigating at the moment. So can you give us an overview of what the chain of events are and the timelines and the desired outcome of what you are doing over these years?
Right. What we brought into London was the records that I spoke of that the officials have known. There's an initial record made before Gough Whitlam created this new title for the Queen to adopt. And it's a record from the Attorney General to the Department of Trade and Foreign Affairs. And in the second point, it states there's an absence for the authority to create or alter the royal styles and titles. Now, that statement says, you can't make a title for the Queen, we don't have it. And yet they went ahead and did it. So the High Court in 1942 said, if a Commonwealth Parliament makes a law without power, it's a pretended law, and we all have and we're all entitled to disregard it because it's invalid. So what they've done is they've created this pretended title to the Queen that breaches our foundation law at clause 2, which says that they must use the title of the Queen in the sovereignty of the United Kingdom. And those words in the sovereignty means their authority and their liability. The Queen of Australia is not that. And this comes now to another point that we've lodged in London. There was a report done by a constitutional committee in 1988, in fact, 2 reports, and they identified this problem that they were breaching the law of the Constitution at the second clause. And secondly, that they identified they don't have the authority to make an alternate title anyway. And they proposed in their first bill in the report that they alter the Constitution to recognise the Queen of Australia. Those things are admissions. They didn't have authority to run under it, for which they had been doing they were into the second decade at that time. How could they know they had no authority and continue? It just smacks of it being totally bizarre, beyond belief. It was like Goebbels says, if you could fabricate a lie big enough, people will think that it's true. And these are the records that show the government knew. It's not catching them out now. They caught themselves out. And it was published, but it wasn't widely available. In fact, it was pretty hard to get this information. And currently, these reports are lodged for access in a part of the OSLI database that's known as Indigenous Resources. And why it would be there could be anybody's guess, other than to be concealed.
So where does that take us now? Where are we now, and the work that you two are doing, and with the OTSF? What's coming? What's transpiring right now, and what is coming, and what's the end?
Well, there's a shoe that's about to drop, and that shoe is the attention by the High Court of Justice to see whether or not Her Majesty had been removed from law operation, not removed from law itself, but from operation of the law. Because what they've done is they're saying the Queen has no place in Australia, legally Australia, which is not the same political body that we've had since 1900, which is the Commonwealth of Australia. And that is basically a war of word art. They've suckered everyone in by getting people to believe that Australia is the Commonwealth, and it's not. If they had the power to do this, then Australia would be a foreign jurisdiction to the Commonwealth. but they didn't have the power. So the attempt to create it is now pretense. So the Commonwealth of Australia is there in law. It has never been abandoned in law, but they have been practicing on a different field, saying we haven't committed an offence over on that field because we're playing on this field. And that's the cleverness of it all. It took a long time to work that out.
So, Peter, it's a constitutional correction is the ethos what we must do, and Neil is one of my key advisors. We discovered a lot of documents whilst I was in Parliament, and you know, as everyone knows, went down in the statute books. Even the High Court was not issuing its writs according to the laws. So. And they had to go back and say, oh, gee, it was a mistake. So I guess we just need to, what we all need to do is just come back under our rule of law, so that we are a better nation, because this not just only affects people's rights, it's, you know, foreign affairs and trade and treasury, and it has a reverberating effect. So we have to act on what we've seen, the presumptions on the table, and unfortunately this Australian government is not recognised under our Commonwealth law, and that's a real concern.
I hear what you're saying, but what is the solution to this, and what are the, I mean, how do you paint us a picture 6 months, a year, 2 years down the track, if and when you're successful in doing what you're doing?
Okay. Last year, I was in London to promote what we're currently doing in court. And when I came back, I spoke to Rod about the proper approach, that we needed to bring more weight of evidence to the table of the court. And so we gathered up more of a library to present, to make the case twofold. One is that there is no opportunity to go into an Australian court and get remedy for our position, because if they acknowledge that, then they wouldn't be able to say, well, we have power. The second part of it is we had to prove that the Australia Act that they created in 1986 to remove all the states from the Crown and close the doors in England to Australian affairs, we had to prove that that wasn't a proper legal barrier for the courts to deny us a hearing. So we've done that, and it's before the court to consider it and provide us avenue to go in a major way to argue the matter fully and present even possibly more material. It's the operation of the English law that we're saying that has been denied us. And we believe the courts can't deny us because the law doesn't allow the courts or the government to deny Her Majesty's operation in law where it's written into law. And if they denied us, they would be denying Her Majesty's operation of law. And that's contained in the Treason Felony Act, which is serious business. And I don't think they will place themselves in that peril. They've done that over here, but people don't really understand how all of that works. Now, where I spoke initially of Whitlam and making that note from one department to another as a legal advice, that's identified as minute 445 of 1973 by a gentleman called Lyndall, who worked as a senior legal officer for the Attorney General. We only discovered that last year, to have something so far back at the beginning that admits their inability to do what they intended to do. But they did it anyway. And that is before the court. So what we've got is the government of the Commonwealth turning themselves into the government of Australia, created it upon a lie. And it's gobsmacking to realise that such a document exists for official records that they knew. And what that translates to is, under a law principle or law doctrine, where company directors and CEOs tried to feign that they didn't know what happened within their company at a lower level and tried to escape liability, it's a thing called willful blindness. And under willful blindness, the doctrine goes, if you could have known and you should have known, it's taken, you knew. So it's regardless of whether they took the time to find out or whether the circumstances led them to it. But all the judges and all the government officials, they're bound to that doctrine of willful blindness. The documents exist, and we've actually had the defendant, who's the Supreme Court Chief Justice, admit he knew of that document, which is possibly why he didn't want to reveal his oath, because with all of what we had, he would have been caught, and he didn't want to acknowledge that. So this is all before the court with other documents. Where I got involved in an earnest way was back in 2004. I asked the Department of the Prime Minister and Cabinet, who's responsible for the Royal Styles and Titles Act having been created, and they administer it. So under the Freedom of Information request, I made the request for, by what constitutional authority does this law rely on to be valid Commonwealth law? And they came back and said, after search of the files and records of the department, they came up and admitted that the authority does not exist. Now, that just blew me away when I received that in 2004. And I'm thinking, I'm sitting on the hottest document in Australia that denies the authority of every state government and the federal government, amongst other things. That there's been no law that's been properly made because it hasn't been under the correct title. They've been doing it under a pretend title and creating a seal for Australia and removing the word Commonwealth from everywhere, denying our authority under a pretended title. And so they've done it in such a way that people think that the Queen of Australia is the Queen of England. And in a descriptive way, it is. But as a title, it's not, because it means another thing. Not only does it mean another thing, they didn't have the right to create it as an authority. So when I had that, I moved on and researched further, and there were several other people who also adopted my request to get their own piece of evidence. And there was a gentleman named Lyle Semth in 2004, about 6 months later, who got his and published it on the net. And then two gentlemen, I made it again in 2006, just to be sure, with several other authorities that I requested for them to provide, and none of those other 6 existed either. So I identified 7 now, things that they have to have in order, and they didn't have them. And then 2 gentlemen, one in Melbourne and one in Fremantle near Perth, they adopted and made the same request, and it came up, it didn't exist. So nothing changed over time. They never fixed it. And then I was working for a gentleman who made an inquiry with the secretary of that department. And this gentleman said, well, I've got these 5 FOI documents. And then citing the Legal Dictionary of Australia and putting down 6 definitions that required a legislation to be validated against the Constitution. And citing the High Court case where if a law doesn't have authority, it's pretended and it has no legal effect. And then citing the reasoning of what was contained in those FOI documents came down to a conclusion that the Royal Styles and Titles Act isn't valid law to create a title for adoption called the Queen of Australia, and it cannot be used for any legal purposes. And the secretary did not acknowledge our inquiry. We sent a reminder, and all of a sudden one of his officers said that the secretary disagrees. So, having cited no reason why he disagreed, we asked or produced a document to produce, and for those reasons. And 2 weeks later, it was announced on media that the Secretary, Michael Thorley, had left office. And he felt the heat on being responsible for perpetuating and maintaining this fraud. That's quite serious, and he knew it. So the next secretary came in, and he didn't wish to acknowledge what went on. And so we went on to further research and attempting to convince the courts that we were right. But these courts can't acknowledge that and won't give us proper hearing and address to the issues, as I, myself and Rod have found out. And that conversation with Senator Culleton last year came to the conclusion our only opportunity is in London, where there is a Crown Court. And that's where we are now. And we don't believe the Crown Court can deny Her Majesty's operation that's set in law. Until they say otherwise, we have a duty under our law that established the Commonwealth to maintain it. And we're maintaining each other's authority that was taken away all those decades ago. So we believe that the Crown is bound to uphold Her Majesty's right in law, and therefore the Commonwealth, which is the Australian people's authority, and her coronation oath makes a reminder that she promised that to rule and serve the people of Australia in her capacity as a Queen of the United Kingdom, which brings in all of the Crown law, which is our protection. If we were to go to Republic, we'd have to figure out how do we bring all of that protection in and make it so that it can't be undone, like the government has currently done, for the purposes which hasn't been identified. So that's where we are.
So this is a very historic moment.
Oh, absolutely, absolutely. And it's our duty. And you know, like I said in your previous podcast show, you know, it's not too often a person goes into federal parliament and cites what we have been, you know, the evidence, Peter, and be bound to an oath to his fellow, you know, fellow Australians or whatever, and then go before a court. And in the back of your mind, knowing that the court is not sitting within jurisdiction to the rights, the constitutional guarantees that we're afforded through, through the Constitution and extending out to the state constitutions. We have a constitutional guarantee. And, when you have evidence and knowledge, the Lyndall Report and the 1988 Constitutional Report, where a number of the highest legal minds signed off on that report, and, even my own experience, drafting up the terms and reference for the Royal Commission into the banks, and then saying to Malcolm Turnbull, well, you do hold the executive power. This has to be a bona fide Royal Commission when we've got knowledge that we're under Queen of Australia, an adopted title. How can that be a Royal Commission? And I said, there will be no remedy through any Royal Commission in this country. It's just a feeding fest of lawyers and whatever, and we've seen it play out. Where's the penalties that are put against the offenders that have been brought to before these commissions? And they don't. They just let them go under this Australian law. But if we had a bona fide Royal Commission, it brings in the Crimes Act. So it's been a very, not too many people make it to the big stage, and I have to be true to myself, and I've copped it pretty hard through the courts and blown a lot of money. But at the end of the day, I've got to be true to myself, my family, and I'm just so overwhelmed that the tribal people, the originals of this country, have really, came forward and approached me over my maiden speech, and just couldn't be happier.
Well done, mate. Well done. I want to talk to you about that, Rod, just briefly. Is that I've been privy to some of this information with the OTSF, and how do we get to that place where you're working with the tribal people of this country, because they've got their own perception as well, and their own beliefs and their own understanding of the law in which we inhabit this country with them. So how do you find that common ground together moving forward?
Respect. It's respect and a Commonwealth tribal mateship. We're all Australians. We've got to respect their law, which is LORE, and equally they've come out and said the elders are respecting our law, LAW. I mean, to actually sit down with the sovereigns of this country and put our differences aside and have them come out, and they're recognising the problems, and people can't afford justice in this country. I mean, I'm one to vouch for that. And it is so wrong. We've had part of the reason for myself getting into Parliament was the simple fact that we're seeing great people lose their livelihoods, everything they've worked for, the destructions of families. I used to have scheduled meeting with young fellows that were in the family court, and then they were cancelling the meetings because they'd committed suicide. Young strapping lads, and this is not Australia, mate. We have a duty to leave a great nation to our future generations. And I've had a big monkey on my back, Peter, and I don't want sympathy. I just want law and order, because when I went as a federal senator, when you give an oath, you've got to, without fear or favour. And I've had to cop the ridicule. I've had to keep my family balanced. I've lost respect of my brother-in-law, but nowhere along the line did they ever follow proper due process. I mean, this issue of sending me down to a public court and abusing my parliamentary privileges, if you let that sit up and be front and centre, who am I and who is the law? And we have a law, and we must respect that law, and we must respect one another. And I'm so honoured that the original, the sovereigns have recognised that and have taken heed of because nothing takes away my maiden speech Peter, and I've experienced a lot, and a lot of Australians have experienced a lot worse, and I'm pretty fortunate, but it just can't keep going on because there's no respect, and we need to restore that respect, and that's the way forward. And going to the UK is our remedy. We have to go to a jurisdiction where our rights are upheld.
And then what flows on from that?
If I could make a comment there to support Rod's, there's a law that says, "Do unto others as you would have do unto you." And if we're going to have our rights respected, you would have to respect everyone else's, both the tribals, both the people of Australia and the Queen's. Because if you don't, if you cut out any one of those, you're showing how they can treat you. And it's, the same Mandus operation of how one goes forward, like Gandhi and other leaders like Mandela and famous people through English history. It's about honouring your right. And that's also what ended slavery, because we've got to have some principle that's got to be permanent, something that endures time. And we're supposed to preserve all that is a right so that our children and their children can enjoy that same thing, because people fought for us to have that currently.
Absolutely.
We've got our battle to do now.
Absolutely. We have a duty. We're duty bound. So, yep, it's the biggest constitutional correction. I said it in my maiden speech, Peter. There will be a constitutional correction. You cannot keep going the way we're going. It just can't happen because the law says it can't.
Oh, and one more thing about the matter in London. The legal representative for the two defendants being the Supreme Court Chief Justice, who's also the administrator and the Deputy Governor for the state. The second defendant was the Governor. The legal representative, the Attorney General, has chosen not to make an appearance for the defendants or to file a defence. My belief is that they can't deny the evidence. I think it's the evidence that speaks of their fraud and their lack of authority, that they say they are something they're not. That is, they don't want to submit themselves before a Crown Court to answer. And so therefore, that speaks volumes in itself.
So let's fast forward. When this goes through, what happens to the government here in Australia? What would that look like? Would it look different than it is now?
I advised Rod that in order for us to get things set right, the authority of the Australian people needs to be put back in place. And we can't do that without the Commonwealth as established. So the first point of order is to bring in a Governor General and governors of the state that represent the Queen of the United Kingdom and the Crown. And once they can do that, we can get correct writs of elections issued. And from there, the Australian people can then decide under that correct jurisdiction to set government again as it was prior to 1973 in the Commonwealth and prior to 1986 in all the states. So that's going to be a long-winded exercise, but I believe that there may be a caretaker put in place, and then once the correct government has been put in place in the Commonwealth and the states, the tribal people can then have their leaders negotiate a new beginning, I believe.
Yeah, treaty, a bona fide treaty. So and GAP is giving that, Great Australian Party is giving that platform of getting true representatives to go in for honest governance. So that's what needs to happen. And that's why GAP, we're doing this politically as well and giving the power back to the people. So we're straight guts, we're not left or right.
And then what would that mean for mums and dads, grandparents listening to this at home? What would change? What would be the I guess maybe benefit isn't the right word, but what would be then the understanding?
Well, the grandparents would have a very clear understanding. The young children would be taught the Constitution and be made more aware, because how would they ever know what was taken from them if they never knew what they actually possessed? And GAP is about bringing back teaching the Constitution in the schools, and because it's a foundation law, it's the fountain of justice, and we are all bound to it. I mean, the clauses clearly say it in clause 5. So it won't take long, because there's a lot of awareness out there, Peter, and like I say, to have the originals come forward and actually spot the problem like we've done and recognise that's a good sign. And that's the key to it. It was always a key to bring all Australians together for the good of all and recognise, hey, we do have a law, we do have rights, and we need to uphold those rights. And the only way to do that is bring back honest government. And that's the ethos of the Great Australian Party and the ethos of my advisors here, Neil and Darren and Daryl and my supporters and even yourself. It's about let's get this show on the road and get the job done. And we can do it because we've got the law on our side.
So is this a certainty? I mean, there are not many things in life that are certain, but do you see you winning this?
I don't see myself winning it. I see all Australians winning it. And we've put the flare in the air. We've passed the baton. I just know the Australian people, well, under the system that we have, the Australian people are the supreme authority. And, I mean, look, we're only in Parliament for a short time, triggered off 44 of the Constitution. A lot of those members fell. They were found sitting ineligible. I mean, how much more do you have to come and show the public of how broken the system is? I mean, I triggered that off, but there's a lot of members of Parliament that aren't lawfully sitting in that Parliament, and you can't deal with it under Australian law. So the whole point is the UK has an oversight. The UK is the remedy. That's where we have to go. And I just think the people now, with us making it public, have a duty. Otherwise, if they don't deal with it, they're complicit to it. We've got to hold them to account, and that's what we need to do. Truth will win out, and we have a duty. Look at the people that lost their lives for this country, for our freedom today, and that's why the grandparents will understand. They lost a lot of their children at a young age, going to war, fighting for this great nation. Come on, we just can't sit back and let's not forget all this, And that's what it is. And it like I said, to be honest, over this week, a monkey's come off my back because of actually being put into that position, sort of having knowledge of it and saying, there's only one way out of this, and I've got to go through and have all the shit thrown in my face. But if that's what it is, I'd rather a shit than a bullet. So that's really it. A lot of people sacrificed a bullet for this country. I just need to get forward and get the message out there. So that's it.
Neil, Rod, love you too. Thank you so much for your time today. If there's anything else you'd like to finish off with, to feel free. Otherwise, I won't wish you luck. I stand next to you and, do what's right.
I just need to say that never was there a proudest moment in the history of Australia to sign a memorandum of understanding with the sovereigns of this country, to where they took a step. They gave a commitment to respect our rights, and we gave the commitment to respect their rights, and they're sailing alongside of us. I just think that is the most. I'm just so impressed with them. Words can't describe it, Peter. And I know I get emotional with it, but it's just beautiful. That's all I can say. Beautiful. Okay. And we have so much talent in this country. Just give people a go. I look at, like I said, I look at the TV shows, and when people get a chance to sing on a stage with in The Voice and all that, if they never had that opportunity, we would never experience their talent. And we've got so much talent in the original communities, just all Australians. And we need that talent to come forward and shine. And I reckon today or this week has just been, it's just gone off beautifully. And I'm so proud. Thank you.
Thank you. And thank you, Neil, as well. Gentlemen, have a wonderful afternoon. And I look forward to sharing a meal with you too very shortly.
Yeah.